let me begin with a deep breath. 14 days of wait, and with some hiccups. Finally on the pitch. However, Milords, we are dealing with Kashmir, Milord. If one goes to Kashmir, Milord, 14 days are not enough. I think Mr. Zafar Shah will vouch for that. And even a month will be, Milord, less. There's so much beautiful scenery and so much beautiful and nice people, Milord. And a nice culture. So what one thing is there, Milord, with this proceeding, the learned councils, what name? When you play a match on the pitch, then you don't watch the scoreboard. Oh, you forget it. So one thing is clear, Milord, that the learned councils on my right, Milords, they have very ably, Milord, put forward the case for the rights which the people of Kashmir, or at least some of them, feel vest in them, and the desire to see the continuance of 370. Nobody can say, Milord, that the lawyers who are not from Delhi, they have taken full care, Milord, of the interests of those who believe in the continuance of 370, and even the world who is watching should see, Milord, that the emotions with regard to Kashmir are not only running in the veins of people of Kashmir, but the whole of the people of India. They are concerned with Kashmir. One way or the other, that's a different matter. Which way the judgment goes is another matter. But we are all concerned with Kashmir. That's the stature of Kashmir, Milord, in the hearts of all the people, Milord, 1.40 crores. Milord, the other aside is, Milord, that I was wondering, Milord, taking a cricketing analogy, just a little aside, Milord, that when we walk into the pitch, the opening batsman, Milord, is one finds with the guards and thigh guards and elbow guards and helmets nowadays. But our, Milord, opening batsman, Milord, the learned Solicitor General, when he walked up, he did not walk up any pads, etc., Milord. And that reminded us of the period of Sunil Gavaskar, Milord. We never had wear, Milord, the head caps and all that. Only the skull cap was there. So he didn't start by saying, Milord, that these constitutional orders carry the presumption of validity, Milords. These are all available, Milords, to the state to stand up and say, which your lordships, of course, keep in mind. One, that there is a presumption of validity, Milord, which they have to, the burden is on them to show that unquestionably, undoubtedly, the only conclusion is what they are conversing for. The second principle, Milord, is that if there are two views possible, Milords, with regard to 370, sub Article 3, then that view should be adopted, which sustains the exercise of power rather than it defeats that exercise of power. So the burden on them is to show that what they canvass for is the only view possible.
Mr. Dwivedi, which IA are you appearing in? I'll be just like.
I'm appearing, Milords, in writ petition 1070 of 2019. And I'm sorry, IA number 84479 of 2022, I apologize. In writ petition 1070 of 2019 and writ petition number 1162 of 2018. Both of them are by the most popular PIL petitioner in the court today.
Ms. Manohara Sharma.
No, listen. Nowadays he is not that popular, Mr. Upadhyay.
Oh.
Your arguments, Mr. Dwivedi, have to be very brief.
Mr.
My argument was?
Arguments have to be very brief. Because Mr. Upadhyay feels that a delay in justice is occurring, so therefore there must be very, very concise arguments and finish. That's his view in public domain.
In fact, one question which has troubled all of us is when my Lord the Chief Justice asks how much time you will take. So, now being towards the end, it won't be too long, but let me see how crisp I can be. So, these are the two fundamental basic principles. And in constitutional matters, it's always possible to take two views. Even if the basic structure doctrine was 7:6. So these are all always highly debatable. Ultimately, your lordships have to decide which is a better proposition to take place. Just as in that case, what tilted the balance was that if an absolute power is granted to amend every part of the constitution, then many of the fundamental values can suffer destruction. So therefore, that caused the tilt. But there also, lordships did not say basic structure cannot be touched. It can be abridged, but not destroyed. That was the concept. So coming to 370, lords, I have some divergence from what Mr. Salve submitted. It's not in opposition, my lord, to what he generally submitted, but some divergence. Yes. In our camp, my lord, fortunately, there is little divergence and contrast. Unlike, because those who are claiming that that's the only submission, I find a lot of contradictions amongst the lawyers. Some saying something, something trying to say quite opposite to that. But that apart, my divergence is about the character of the power of the president. Mr. Sibal said it is executive, president's power. Mr. Salve says it's legislative. I say, my lord, that this power is a constituent power, much wider than Article 368. The fact that it is vested in the president is for the special reasons which existed when it was framed. It's a constituent power. A power, because the lordships in the 5 judges' judgment say, Puran Lal Lakhanpal 2 probably, that modify is very wide. Efface. You can say even 136 will not apply. Ordinarily, independence of judiciary, if anybody touches 136, it will be struck down as violating basic structure. So the power to modify and accept under D is very wide. Well, there are 5 kinds of constituent powers in the Constitution.
Yes.
The first was the original constituent power in exercise of which the Constitution was framed. The widest term, you could have framed anything you wanted. Whatever kind of federal structure you wanted. The second one is the ancillary constituent power. That is something looks like Article 238 was that for certain period of time, the federal structure stands suspended. The central government will control Part B states and develop those structures and ensure that it comes up at level. And that's very important. It doesn't apply to Kashmir, that's one thing. But the idea was that the central government should take steps to bring it up at par, those states, Part B states. The other was 306. In the chapter of free trade and commerce, where certain states were very much interested in continuing with the power of taxation, particularly Travancore, Cochin, because being on the port, their entire income was found based on the export and import duties. So therefore, 306 permitted for a certain period those states to impose, levy and collect tax. The 370 is another power, of that kind. All three, the purpose is to have some time period, some temp period, so that bring it to the level of the normal federal level. Asymmetry, is completely different concept. Some tribal area may be lagging behind, some state may be lagging behind, some state may have some special features, so you may for some time allow them certain special treatments. All these detailed provisions which are read out to your Lordship 371 G2 dealing with the Northeast and Andhra Pradesh, Mizoram, etc. They have nothing to do with bringing at par. That is to protect the tribals and so on. But these three articles will not stand on a different footing, and their objective is to give a certain breather, certain time, so that in due course, of course, the manner of alignments, how it will be brought in are different. So
Article 238 was not limited in time, right?
No, but ultimately by 56 it was
right. It was
intended to be a permanent feature. That's what I mean to say, Rose. Under the policy documents, which I will read out to your lordships to the relevant portions only, would show that the idea was because the different Indian states were in a different state of development. Some were so small they could not hardly afford to have a legislature, etc. I know. So state structure could not be supported by them. So like even in Himachal Pradesh, they had to be collected and put in one. So many union of states had to be carved out. Many small states had to be just merged. They could not afford to have a state. And though even those who formed a union, they hardly had a constitution. That it required a time period to build a constitution for the United States. So for various reasons, in various phases, things developed. And so finally, the federal structure which was formed, even at that stage, there were pulls and pressures. So certain compromises struck. And these three articles, therefore, are ancillary constituent power. They are continued. This is very significant, with the process. For example, for 370, the process which started with the framing of the constitution, it was understood, that this is to last. They don't fix a time period, though they have put it in part 21. No specific time period is put there, but it is expected, that in due course, as Nehruji and Guzari ji said in their speeches as prime ministers, that slowly B1, B2 and D will be used and the alignment process will happen, and slowly a time will come where really nothing remains, then put them at par and finish it off. This is meant, therefore, to slowly align it bring it at par, and terminate. So it's that continued process, and that's why it's an ancillary constituent power. The third is, my lord, the amendatory constituent power in 368. And in the context of 368, I will just give your lordships the paragraphs, not separately, not of the different judges, not who held that the power under 368 is constituent, not, and that's why Golaknath was overruled, not. Though ultimately in the process, not, what was created was the super Golaknath. So the limitations were in Golaknath were only fundamental rights, but now it's a much wider domain. Essentially, what I rely upon on those portions where the ordinary law and the constituent power have been distinguished. And the distinction pointed out is that where you are amending the constitution, constitutional provisions, then that power is constituent power. Ultimately, 368 so therefore, and if you compare 368 and 370, located in the Constitution in proximity, the width of amendatory power, at least as the law stands now, basic structure cannot be amended there. But here, so far, nobody has paid any heed to the basic structure. 35A has come in, and a whole lot of things. 136 was applied much later. So, Comptroller Auditor General came much later. So, all the basic fundamental features, they were missing. So, it's much wider than the amendatory power. So, it cannot be described as an ordinary executive power of the president, or even a power which is legislative in the nature of an ordinance making power. So what your lordships deal with today is a constituent power. And this constituent power, Lord, is laced deeply with elements of act of state. To illustrate, Lord, Article 370, sub-article 3, if the proviso was not there, which lasted for a few years from 51 to 57, then it is nothing but an act of state. Anytime he could have said end to 370. So the constitution makers, instead of leaving it for the state to act supra-constitutional to annex the state, they provided a particular procedure to avoid that happening, so that it happens as far as possible, with concurrence, consultation, recommendation, and a period of time lapses when, it is felt by the people as a whole in the country that the time is ripe. That's what Iyengar said. When the time is ripe, Jammu and Kashmir will stand at par. So who decides when the time is ripe? 373 will not continue because of emotional reasons, sentimental reasons. As my Lord Justice Gawai had said, this case can't be decided on sentiment. Sentiments are on both the sides.